And that's kind of, I don't mind saying this has nothing to do with it. But I even find that when I'm on YouTube or something, I want to see something. If it's more than 5 minutes, now I say, I don't know if I want to watch it, right? I want it quick and what you got to say and move on.
Good morning, Your Honor.
Yes, sir.
Jonathan Fountain.
Let's go ahead and let everyone set forth their appearances. That's the only way we can do it. Is that correct, ma'am?
Yes.
And then we'll take a break. Go ahead, sir.
Jonathan Fountain on behalf of NSF International. And I'm appearing today, Your Honor, in the consolidated Henry case under this matter, and specifically with respect to NSF's motion for determination of good faith settlement with respect to two of the plaintiffs, Pete Deontay Henry and Trevor Abele. And as the court has noted, the motion is unopposed.
I understand.
So we rely on our papers unless the court has any specific questions you'd like to ask me. I have a proposed order I've prepared.
And I have no questions right now, but let's make sure we note our appearances for the record before I step down. We'll start with the plaintiff.
Your Honor, Will Kennedy, Eric Pepperman for plaintiffs.
Good morning.
Good morning, Your Honor. Joel Odou on behalf of the Real Water Defendants.
Morning, sir. Jim Neale on behalf of the UNFW and Whole Foods. David Spurlock, UNFW and Whole Foods.
Good morning, Your Honor. Jim Cavanaugh for defendant EGT1 LLC DBA Terrible Herbs.
All right. And do we have appearances on the phone?
Good morning, Lorene Frister for Cahey Distributors of Nevada.
All right.
Caitlin Zaff, also for Cahey Distributors of Nevada.
Good morning, Your Honor. Colt Dodrill for Nevada Beverage.
Good morning, Your Honor. Daniela LaBounty on behalf of defendant Costco.
Good morning, Eric Freeman on behalf of Real Water.
All right. Does that cover all appearances? Okay.
Could I get your name again? I apologize.
Jonathan Fountain, like water fountain.
Thank you, sir. Thank you.
And I guess for the record, before we take our quick break and then we'll come back, we have unopposed motion for good faith settlement. Is that correct?
That's correct, Your Honor.
Okay. And that's defendant NSF's motion. Is that correct, sir?
Correct.
Okay. I'll grant that. Okay.
Your Honor, consider the proposed order I've drafted.
Yeah, you can submit it to the inbox and we'll get it signed today.
Very good. Thank you, Your Honor.
All right. And I guess the other motion for summary judgment on all claims, that becomes moot. Yes, right. Okay. All right. So what I'm going to do, we need to take, my staff's been on for 2 hours plus. They need a quick break. We'll come back and deal with the jury questionnaire issue. I can say this before we have some discussion. I don't remember ever denying a request for jury questionnaire. So you got to convince me on that one. But we're going to sit down. We'll step down for about 5 minutes.
Your Honor, with the court's permission, I'll excuse myself having settled the cases.
Oh, of course. Have a safe trip back to Virginia, sir.
Thank you, sir. Thank you very much.
So when is this case going to ultimately resolve itself?
You want the real answer, Your Honor?
Yeah, the real answer.
I'll write this down. We have the record. The real answer probably 2 weeks after we cast liberty in judgment. That's the real answer.
Okay. Oh. And we're on the record, ma'am.
We are.
And we've already noted our appearances, right?
Yeah.
And yes, we have one remaining issue. I'm going to take a look.
Well, Judge, I don't think anyone objects to the questionnaire. There were some questions that UNFW objected to, but now they're gone.
They're gone.
But some people joined in their thing. So I think probably the best way to do would be, you know, who's got a problem with questions and what's the problem? We'll just go one by one.
All right. And I haven't looked at it through this lens, but is this primarily the same one we used before, right?
Be the fourth time we've used it.
Fourth time we've used it. And this is what's really important to point out. I don't mind telling everyone this. I've made my decisions when it comes to jury questionnaires for a couple of reasons, but one of the primary reasons is essentially this. I mean, I look at the, well, there's two reasons. Number one, you have NRCP 47A, and that deals with the trial court and specifically how it conducts voir dire. And I kind of look at this as an extension of that, secondly. But this is another reason why I do it, because if you take a look at Nevada Rule of Professional Responsibility 3.5A, and I think I placed this on the record before, but it's my recollection, subsection E is Nevada specific, and it's not contained in the model rules when I took a look at it a while back. And the language in E is very compelling. It says the lawyers may, quote, investigate any basis for challenge, close quote, right? And the limitation is this, though. You can't go out and have direct contact with or indirect contact with the veneerman or the panel, but you can investigate, right? And I think what really is insightful to me is this. It says any basis for challenge. It doesn't say cause challenges, because it's implicit historically, because our Nevada Supreme Court has always had a very liberal policy as far as jury selection is concerned in voir dire. And if you read all the cases, it's pretty clear in that regard. But I think our Nevada Supreme Court understood that you have potentially peremptory challenges in your back pocket. And you might have of course, a legitimate basis for a cause challenge. And you're given the opportunity to develop that, of course. That's your right. But just as important, too, you have a right to ask questions that might not necessarily rise to the level of a cause challenge, but you have to have an educated basis to exercise your peremptory challenges. It shouldn't be just eeny, meeny, miny, mo, and so that's why I permit it. And just as important, too, I do it, I think, a little bit different. I actually, with all these jury questionnaires, I go down personally and I actually have the jury or the panel sworn in. And I talk to them a little bit about why it's required to be forthright and truthful. And just as important, too, I explained to them, I said, look, you got to fill out the questionnaire completely, and if you have a hardship, you better set forth that hardship, because I'm going to review it, and I ultimately make that decision as to whether or not the hardship is legitimate or not. And then I explain to them there's a difference between an inconvenience and a hardship. Big difference, right? And so on. But are there any specific issues I need to look at in regards to the questions set forth in the proposed jury question?
Yeah, Judge, if you take a look at our reply on page 7, right, we start going through the Whole Foods request for additional questions. And like I said before, I don't know that the remaining defendants are joining this, so this may be moot. But if there's anyone joining them, that we need to go through it. And there's 1, 2, 3, 4, 5, 6, 7, 8, or actually there's 6 because we agreed to 2 of them.
Right.
Yes, Your Honor. I would suggest Keehee and Nevada Beverage filed just non-substantive joinders to the opposition filed by Whole Foods. I don't know that they have any particular problem with the jury's questionnaire that we have proposed. We've used it 3 times. I mean, we've agreed to it 3 times. This court was the first one that said it. So I don't know if they even have any remaining objections now that Whole Foods is out, but I think that's the best place to start, to see if they do and what they are, and then we can.
Yeah, Judge, and these are super minor things. None of these are really big deals.
All right, let's hear from the objections.
Good morning, Your Honor. Colt Dodrill, Bar 9000, counsel for Nevada Beverage. I sort of agree with counsel that some of these are minor, and I think we could include those and make everybody happy. Specific concern is request 11 from Whole Foods motion. It's on page 5. It asks to add some questions to question 37 on the questionnaire related to consumption of alcohol. And I don't think those questions, especially 11B and 11C, are necessarily limited to those folks that suffered liver injury as a result. We've got a number of plaintiffs here whose medical records suggest substantial consumption of alcohol. We've got some experts, they've got some experts. That's going to be an issue, and we want to make sure we don't have members on the jury panel that may have an opinion one way or another on the consumption of alcohol so that we can make appropriate decisions.
Yeah. And for the record, I just want to make sure I'm clear. You're saying, look, Judge, and I think this is off of page 5 of your opposition. You want to have item 11 inserted after question 37 on page 17 of the form. Is that correct, sir?
That is correct, Your Honor.
Any objection to that?
Court's indulgent. I'm looking at the in terms of asking if they consume alcohol, if so, how frequently and what quantity, no objection to that one. But we ask them in the questionnaire if they know anyone with any liver disease or cirrhosis and the cause, if any. So that's covered in the questionnaire already. I don't believe there's a question about asking of consumption of alcohol. If there is, obviously that wouldn't be needed, but if there isn't, there would be no objection to that one.
All right. So it appears to me we have some common ground here.
Yeah, Judge, the only objection is they're trying to focus the alcohol and cirrhosis. They're trying to make their causation case. So that's, we object to it getting that specific.
All right. Okay.
And Your Honor, this is Lorene Frister for KHE Distributors, and I would just join in Mr. Dodrill's arguments.
Okay, thank you, ma'am. Anyone else want to join in?
Your Honor, I'll join on behalf of ETT1.
So I want to make sure I'm clear. As far as, I guess, the proposed question, we'll call it 38 since it would be after question 37 on page 17. How do we deal with that? There's no objection to consumption of alcohol, right? What about herbal and or dietary supplements?
Yeah, Judge, we don't object to B or C, but when they try to tie them into a causation, they're previewing their causation defense, which is A and D.
I understand.
So B and C we don't object to. A we think is covered by the question where they know anyone who's had liver injury, and if so, what's the cause?
That's the neutral way to
That's the neutral way of saying it, rather than say, oh, alcohol causes cirrhosis. That's our defense of the case, which is why we object to A and D. So B and C we're fine with. A and D we object to.
All right. What's the problem with the D?
D isn't even specific. They're saying adverse health effects from consuming supplements.
You feel there should be more particularity as far as
I think so let me give you an example, Your Honor. Yeah. So they're saying that Daisy Wee, which is one of the plaintiffs in the case, took supplements. She did, and that's what caused her liver injury. That's what their argument is. They're going to have an expert presumably say that.
Do they have a medical causation expert that says that?
I don't want to argue the motions eliminated, Your Honor, but I think you're going to hear the argument yet again about could have been, So, yeah, but to tie the causation with either the alcohol or supplements at this point in the questionnaire, I don't see any reason to do that, Your Honor. It's just previewing the defense of the case.
Okay. And let's hear from the adverse parties as far as A and D are concerned.
Your Honor, I agree 11A is included in question 36, but I think we would want to know if there's anybody on the panel that has suffered adverse health effects, and we didn't specify in their cirrhosis. We just want to know any health effects of supplements. If somebody has an opinion one way or another on supplements, we want to be able to evaluate that.
Okay, what about A? Okay, I see what you're saying. You said you acquiesce on A. Your thrust and focus is on subpart D. Is that correct?
That's correct, Your Honor.
Okay.
If he's dropping A, I'll give up D.
Okay, see, we have a deal.
Okay.
All right. So for the record, I guess it will be A, B, and C. A will be removed. And it'll be A, B, and C, and it'll be the three questions following that, and it'll be after question 37. Right?
Thank you, Your Honor. I think we could circulate, we could review a circulated questionnaire and get that approved with those changes.
So where do we go from here? What's up next, if anything?
When does the court need the finalized questionnaire from us?
What did we do before? Because I know it has to be some time out there, right? And Lynn is in Europe enjoying her summer vacation.
Yeah, Judge, you know, Miss Schwitzler's been working pretty close with the jury commissioner on these cases, so I think she'd probably be the better one to explore that issue with the jury commissioner. We'll get to her as soon as we can.
Whenever the jury commissioner wants them, that'll be my ruling.
That works.
You know.
Your Honor, along that same line, there's a question on the number of questionnaires that go out. I'm not sure if the jury questionnaire or the jury commissioner works directly with the department on that, or if we are able to coordinate that with the commissioner, we can certainly try. But in terms of the general number, if we have some guidance, that might be.
What did we use last time?
So in the Gallagher trial, we did a lot. It was like 4,800 summonses for, I think, 1,200 questionnaires. I think that ended up being more than we needed. In the last trial, Joel, correct me if I'm wrong, I think we did some fewer number of summonses to get, I think, 600 questionnaires filled out.
Was 600 sufficient?
It was in that case. I think we were getting a little close, although it was summer, right in the middle of summer. The other concern is because of the additional press after each trial, we're always concerned that there are more people in the veneer panel that have seen news media articles or about the prior judgments and things. So for that reason, I would say we probably should err on the side of a little bit more.
We should bump it up a little bit, I think.
Joel Odou for Will Water, we agree. Obviously, the configuration of the case is changing with settlements, but you know, in the last case, we only had two parties and pretty much one party by the time it got to the jury. This case, we have multiple distributors and stores. So I would say at least as many as we did in Wren, possibly a few more would be about right.
800.
Yeah, I thought we did 800 in Wren. So I would say,
we did 600.
Did we do 6?
We called it 6.
I wouldn't do less than we did.
We're not doing less.
Yeah, I think 800, Your Honor. I'm not so worried, Mr. Odou, about the potential publicity because to my surprise, I'm finding out that no one reads the paper.
They don't.
No one watches the news anymore. You know, if you ask 100 people in Clark County if there had been $1 billion verdict here, 99 would say we don't know. But out of an abundance of caution,
I'm saying this on a personal level. I don't watch local news anymore. I mean, a lot of us don't anymore. It's unfortunately we've come to that with so many news sources and outlets available, whether it's on some social media platform and or YouTube or right. Isn't that kind of how our habits are? Yeah.
It was surprising how few people had seen the prior verdicts in the last.
It was shocking, Your Honor. It was shocking. Even 800, I'm fine with it. If someone wants even more, I'd listen to it.
That's fine. Sounds like we'll be able to reach an agreement.
Yeah, 800 is fine. If you feel cautionary, you want to have an additional 200, 1,000. I have no problem with that either.
Appreciate it, Your Honor. Thank you.
Yeah, Your Honor. So are we done for now?
Yeah, we'll coordinate with plaintiffs. So reach out to the jury commissioner and We'll get it done.
Get it done.
By the way, just for the record, the jury commissioner has done an excellent job in the first 3 cases.
Oh, yeah.
I think she is really an unacknowledged person. She has really done a great job.
Oh, she's wonderful, you know, and that's why we try to work with her.
And the JEAs, because the excuses when they start rolling in are very hard to keep up with. And we appreciate the JEAs and all the departments and the burden we put on them.
There's no doubt. I mean, Lynn goes through each and every one of those. She faxes them out to you or emails you. And we try to keep up with that. And so that's fine. So what are the just one last final question, gentlemen, before you leave. What are the probabilities of this going?
I think it's 99.9% sure.
Yeah, I know.
It seems like it.
Seems like, okay. Well, this isn't our first rodeo, right?
And, you know, time frame, I think it might be slightly longer than Gallagher just because we have 15 plaintiffs. But we're hoping to get the case in and out by Halloween. We get started in October.
Well, Mr. Kemp, I don't mind telling you this. What was it? 39 witnesses in 1 week and less than 4 minutes for the
tough record to beat.
I know it's going to be tough to beat, but nonetheless, that's still a record. That's a record. That's the record for efficiency I have ever seen in any trial. And I actually tell lawyers, I said, I had a case and went to trial. And they did 39 witnesses in 1 week. Tell me why you can't do the same.
We're setting the bar,
yeah, that's right. And I think it's important because I think sometimes we fail to realize that, you know, you have lay people and, you know, they're used to taking their news and sound bites. Right.
And I used to think that, you know, they had that headline news, which were 3-minute programs, but now we have TikTok people.
So yes.
Anything that takes more than 20, 25 seconds is too long.
Right. That's why they have the shorts.
Right.
Right. The shorts. And that's kind of, I don't mind saying this has nothing to do with it. They even find that when I'm on YouTube or something, I want to see something. If it's more than 5 minutes, now I say, I don't know if I want to watch it. Right. I want it quick and what you got to say and move on.
You can up the playback speed. They'll talk a little bit faster and higher.
All right. Well, anyway.
Thank you, Mr.
Everyone enjoy your rest of your day.
Thank you.